What's up, folks? How are we doing? So I didn't get to watch every moment of closing arguments today. I would have liked to, but I watched a good chunk of it. I managed to, when I got home, I actually had to take my lovely fiance to a doctor's appointment. But I managed to watch on double speed the defense closing and then the prosecution rebuttal to that closing. And I watched a little bit of the primary opening, but I think the primary thing that was leading to the thing being long was the defense closing. I watched the whole 2.5 hours of it. Part of me worries that the jurors might have been a little bored because, listening to one guy talk at you for 2.5 hours is a lot. That said, I don't know. I thought it was engaging at double speed, so maybe it was still engaging at single speed. But at the end of the day, again, let's get right to the heart of it. I still predict acquittal here. And I'll get to some of these questions. Like, for example, Ann Burns has a very good question about why would the judge not call for a mistrial after Maxine Waters. I'm still predicting acquittal. And the basic reason is I think there's reasonable doubt. I think Eric Nelson did a good job explaining all the places where there's reasonable doubt. And I just think jurors in the process of any sort of lengthy deliberation when they do their jobs will not be able to come to the conclusion here that they don't have doubts about how Floyd died. I don't feel like the prosecution did nearly a good enough job excluding the possibility of a heart attack and excluding the possibility of some sort of the meth and the carbon monoxide and all that playing some sort of role. And that's why I think he'll win. I also think one of the things that Nelson did extraordinarily well in his closing was I think he kind of resurrected the use of force defense and brought it back into play about whether that was reasonable. Cody says they love watching me on Tim Pool. I hope you guys enjoyed that. Yeah. And if you didn't see me on Tim Pool, you should check that out. I did a full 2 hours with Tim Pool and we talked a lot about the CHAUVIN trial. So I was impressed with what Nelson did in terms of revealing, there's reasonable doubt on cause of death. And then I think he also did a good job of using essentially his cross-examination of the expert witnesses of the prosecution experts in order to actually make his case that the use of force was reasonable. I thought that was very impressive because he had a very bad time. His use of force expert was terrible. And so the only way he was going to resurrect that argument was really by not relying on Broad. And you notice how little Nelson talked about Barry Broad's testimony. That's kind of unique. Normally, when you have an expert who makes an important point, you generally rely on them to continue talking about it. Here, that wasn't the case in this closing at all. He barely mentioned Barry Broad's name. And I think it's because at the end of the day, even Eric Nelson recognized during the course of Broad's testimony that it was really poor. And, that sort of that just kind of, it sort of captures why this was such a hard trial for the defense. Just the sheer amount of effort needed and the lack of resources available, it seemed like. It seemed like Nelson was the only serious attorney and he had to prepare all the cross-examinations and all the directs. He did all the work, whereas the prosecutors had a team of, I think, either 3 or 4 lawyers. I think they had 4 lawyers on the prosecution side who at various times were doing direct and cross-examination. And as a result, I think he didn't get the time to fully prep with Broad. I think if he had prepped with Broad, it would have been a much more robust discussion. And also the fact that Broad had his former home, had pig's blood thrown at it just kind of indicates why it would be so difficult to get a use of force expert on this case. I wouldn't be surprised if, there were plenty of people who agreed that the Chauvin use of force was justified, but that did not want to be on the stand in a massively watched public trial saying that. So he managed, but anyway, Nelson managed to resurrect, I think, the question of whether or not the use of force was reasonable by relying on his cross-examinations, which is a very difficult thing, a very impressive thing to do. And I did not think the rebuttal was very good. I thought it was very flippant and mean. Somebody pointed out, this is Ande T on YouTube, pointing out that the state really complained a lot about the defense's closing. I think that's an accurate assessment, and it's not a good position to be in where you're just whining about, the other side's lying. In fact, you had Nelson himself at the end of the trial pointing out, we had prosecutorial misconduct here during the rebuttal where they're just accusing me of being a liar. for no good reason. Indeed, I also really like the judge calling out Maxine Waters. The fact that Nancy Pelosi saw no problem with that, well, I mean, that's a serious state court judge saying that Maxine Waters' behavior was abhorrent, which it is. I.e., if you're encouraging riots, if a jury doesn't go the way you want, that's jury intimidation. Might well be a crime. Somebody says you can, Luke, you can absolutely ask questions, but you have to do it in writing because I don't have the way to bring you on audio in this format. At least not people I don't know. Somebody says they think it'll be a hung jury or guilty verdict based on the demographics of the jurors. I think hung jury is a possibility. But at the end of the day, I think an honest juror is going to look at this and be like, I don't know how he died. I don't know. How do you know he didn't die, right? Because think about what that conversation is going to look like. Like the juror who's trying to say, no, he totally did it. Do they really is that juror going to have the complicated medical, the medical expertise to be like, no, this doctor was right and this doctor was wrong. I just see that debate being hashed out in the jury room, and the side that says we don't know wins. That's I think the basic concept. Somebody says, I think a bench trial would have been better for Chauvin, like the cops in Baltimore. I agree. I think he probably should have gone for a bench trial if he had the choice of the matter. Although I don't know that he's entitled to a bench trial. And I think the prosecutors almost certainly wanted a jury trial here. Yeah, exactly. As Always Warrior says, there's no proof how he died beyond a reasonable doubt. I think there's some reasonable chance he died of positional asphyxia, and there's some reasonable chance he died of a heart attack. And I was unconvinced by the expert witness. Really, the expert witness for the defense was more persuasive because he's just we don't know. This is complicated. It's not exactly clear what caused the death here. But for the prosecution witnesses to get up and no chance, as Nelson did, fentanyl had nothing to do with it. Methamphetamine had nothing to do with it. The 90% blocked artery had nothing to do with it. The adrenaline, the methamphetamine, none of that had anything to do with it. Just the positional asphyxia, which papers have shown generally only applies to obese people. We hold people in prone restraints all the time. Really? I mean, it just seems like it could have been the heart attack. It really could have been the heart attack. So, somebody says, honest juror, that's cute in 2021. This is a test of how emotion has infected the legal system. I don't know. Pardon me for not being super cynical, but I think there are people who are on juries who really do try to do their jobs. I mean, it's a solemn thing to be on a jury. So, I think, 1 out of 12 is going to be serious about doing their job. That's my figure. Somebody says, why do I think Cahill dismissed motion for a retrial on an issue he specifically said he would? So this was, I think I should have done a scope on this last week. I'm not sure if I did, but it was Thursday morning. And basically, I don't know if you guys were following the trial Thursday morning, but the defense made a big deal about potential carbon monoxide poisoning as a contributing cause of death. Not the cause, but a contributing cause. And one of the things that the prosecution decided to respond to the next day on their rebuttal was they wanted to introduce evidence that they were managed to find of one of the blood tests that had never been produced to the defense that would reveal that carbon monoxide wasn't an issue. And the defense was like, whoa, that's prejudicial. We told you we were going to talk about carbon monoxide for months. You had 2 months to give us this. You didn't until our defense is over. We closed our case. Judge agreed, said it was prejudicial, and said any reference to this novel particular test, this test result would lead to a mistrial. The thing is that understand, it was a blood test, and there's a panel of results that come from this one blood test. And so referencing the fact that a blood test was done is not the mistrial worthy thing. It's referencing this particular result, right? That this particular specific blood panel was taken and that there was a result from it. And I'm pretty sure that ultimately why there's no mistrial is because neither Dr. Tobin nor the prosecutors actually referred to the excluded blood panel. They were just referring to the blood gas results generally. That's why, Tobin was like, well, there's 98% blood oxygen saturation, which means he couldn't have had carbon monoxide poisoning. And I think that, Nelson did something clever that Jack Posobiec pointed out. Nelson said that if, I could just get up here and say, well, he had 98% blood oxygenation, which means he didn't die of asphyxia. Right? Clearly there was, he was able to get enough oxygen to the blood of this brain. Somebody says, have you thought about willful indifference? I mean, I could see that, but I don't think that's charged, right?
the sort of indifference to the outcome, I don't think that's a charged offense. I also think that would be difficult to prove because they thought the EMS was coming. Like one of the more effective moments I thought of the rebuttal was when, Nelson was able to bring out the testimony of the off-duty EMT who showed up and tried to intervene, right? And like his cross of that off-duty EMT was like, how long would you expect it between the time you called EMS, emergency medical services, and the time they showed up? And she was like, 3 minutes. They'll be there in 3 minutes. It's like, that's devastating because like that, there's plenty of evidence about, within a minute of, Floyd being on the ground, they called for EMS because they recognized the cut from the struggle that they repeatedly showed. And then a minute after that, they called EMS and they said code 3, which means lights and sirens. So they were like, we are going to have an ambulance here ASAP, right? Like, I don't know how, maybe like they didn't do as good as they should have, but to me, that's not a crime, right? So somebody says, the Crusader Rabbit says, I enjoy your perspective. There are a few channels on YT that are open-minded like you. Well, thank you. If you enjoy this, please do subscribe to Human Events. And those of you who are following on Periscope, I realize, Periscope is still in its kind of death rattle. In order to get access, you should hit subscribe on youtube.com/Human Events and smash the notification buttons so you get access when I go live or get notifications when I go live. So, I'll certainly do some analysis of the verdict when it comes out. As Shadow Demon Show points out, the EMT Karen did more harm than good for the state's case. I agree. Leslie Stark on Facebook asks, what happens if they can't all come to an agreement? Well, then it's a hung jury and it would be a mistrial. And I believe that the prosecutors could try again in a new trial. So let's see. Schwinn Chair says, so glad I live in the country, even if it's Cali, get out of cities. I kind of agree to that. I got to go back to the city for various reasons, but if I could avoid being in the city, I would definitely avoid it. So somebody says, why did the 3 listed defense witnesses not testify in the end? There are reasons to make that decision. Part of the problem of having a defense expert, especially in use of force, is that like the cross-examinations can be pretty potent. Like it seems weird if you have to justify something. So that can be a real challenge. Somebody, Love This Nation said, Floyd said, I can't breathe while facing up in the back of the car. Why didn't Nelson mention that? He did. That was actually a big part of Nelson's closing, was talking about how, how a reasonable police officer interprets, I can't breathe, when George Floyd has been saying that like ever since they tried to put him in the squad car and he was resisting. So like maybe he's interpreting that differently. Also, he made a point of how using the fact, Tobin was like, had said like, yeah, people say if you can breathe, you can talk. And that's just a fundamental misconception that a lot of people have. It's like, well, if a lot of people have it, then a reasonable police officer might have that misconception and thus think that if Floyd is talking, there's no real problem in terms of his breathing. Yeah, that was a really powerful moment. I think AT has a very good point here, right? The thing when Nelson said 3 things happened simultaneously. The Floyd stopped breathing, but right at that moment, Nelson played like the actual video, and you can see the off-duty paramedic walked up, but behind Chauvin and tried to intervene, and he had pulled out and shakes his mace because the crowd was coming on. And like that's the exact moment that you want him focused on Floyd, and it's like part of I think the reasonable use of force thing is Chauvin was distracted, right? Like there was a lot going on around him, and he's like thinking to himself, I'm just going to hold this guy in place till the EMS gets here, and I'm just going to like try and like make sure like this shit doesn't get out of control. Like that's my honest suspicion about what he was thinking. I don't like, again, these people, they all have body cameras. Like that was something I think that Nelson also did a good job of pointing out. Like they're all wearing body cameras. They all know that their behavior like will be evaluated if anything goes wrong. They're not sitting there trying to get away with a secret murder. No. They're all police officers wearing body cameras. Like the idea that they would be trying to do this, it just doesn't make any damn sense. So somebody says the governor held a news conference afterwards and said they needed change. Shouldn't that change start with him? I agree. Everybody who says there needs to be change should resign. Right. Yeah. Thoughts on Blackwell's behavior during the trial? I thought he was really disrespectful. He was very, very disrespectful of the defense witness Fowler. I think he did a really poor job crossing him, right? The other guy, Schleicher, I thought Schleicher was much more skilled. Schleicher's cross of Broad was devastating, right? GG, game over, devastating, just winning. Broad was done by the end of that.
you'll notice Nelson didn't even barely brought him up. But Blackwell's cross, like it didn't, he was like mean to start. He's like, yeah, I mean, with the ridiculous questions, you know, things like, you know, expert witnesses shouldn't mislead the jury, correct? And expert witnesses should try and tell the truth, correct? And expert witnesses shouldn't beat their wives and, you know, rape children, correct? just like planting thoughts of the jury that's totally terrible. And yeah, so I'm not that impressed with that. Somebody says, always enjoy your guest spots on Timcast. Do more. I try. Like, obviously, getting on Tim Pool. Tim Pool is a, you know, he's got a big audience. I think Tim Pool's audience is crazy. They got like 35,000 live viewers generally. I mean, his audience is what, like 35 times this, and there's like, we got like 800. So, you know, I'll work to get to, I need to be more consistent about generating content. Somebody says, how can you advocate for imprisonment while advocating for no incarceration? I mean, yeah, that's a good point, right? Like the jails are bad except for the police. Like the only people that the left wants in jail are police officers. Jane Love asks, is that why they had sidebar, referring back to Blackwell being rude and asking those questions? That's exactly why they had sidebar, because that's what the judge told him to knock it off. Somebody says, can I talk about peer pressure that happens in a jury room? I would be totally speculating. I've never been inside a jury room or seen a jury try and figure things out. So, you know, I wonder if the prosecutors, like, one of the things you can do, this is something people don't know, is you have a really, this often happens in like a big money litigation, right? Like big money patent litigation or something, is that they'll spend the money to do like, you know, a big law firm will spend the money to do a mock trial and hire mock jurors. Like they'll bring in people off the street, contractors, and they'll present their case and they'll try and present a trial. And then they'll have cameras in the mock jury room and they'll listen to the deliberations to get a better feel for like how the juries are responding to certain things. And that helps them shape their arguments that they use for the trial. I wonder, I mean, the prosecutors had a lot of resources, right? You have like multiple pro bono attorneys in this case. I wonder if in the past year, they had the opportunity to mock this and how it went for them. So Jay Marie asked what I think of Derek choosing the Blakely waiver. So that is my understanding. I don't know if Blakely is a Supreme Court case. This might be an area of criminal procedure that I'm not actually familiar with, but I'm literally, to clarify, like, I have not researched the Blakely waiver, and I literally just learned about it today. What it is, based on watching it, I figured out what it was you can waive your jury trial right and have the judge decide if there were aggravated circumstances that would lead to an increased sentence, right? The prosecution is seeking to have aggravated circumstances applied and thus ramp up the sentence. And so you could either let the jury decide that or the judge. And I think it's very smart to say the judge should be the one to decide that, because that only comes into play if the jury finds him guilty. And if the jury finds him guilty, I don't want that same jury making the decision about aggravated circumstances. I want to give it over to the judge. Also because I think that a judge is most likely to say that there wouldn't have been aggravated circumstances. Adam Townsend, my bro, says, I don't think the jurors can withstand the threat of protest and violence. If they find guilt of something, they can kick the can to the appeal. It wasn't me. I don't know, maybe. And I think that there's a really good chance of a reversal on appeal for failure to sequester the jury. Like that's actually seems like I think that might well be reversible error in the circumstance. I don't know. I just think they can. I think people can. I think there's going to be one juror who's, you know, at the end of the day, the juror is not going to be so afraid. Like they're like, our identities haven't been revealed, et cetera. And I think, you know, one juror's going to be like, it's the wrong thing to do to send this guy to jail if we haven't. We need to follow the judge's instructions. I think if they follow the judge's instructions, they'll come to a not guilty verdict. Maxine Waters overstepped her limits and should be held accountable for any violence in the outcome. I mean, this is really basic stuff, guys. Like, you do not try and intimidate jurors. I really don't like, you know, and I'll be frank, I didn't like it when Trump tried to intimidate judges either. Right? Like Trump would shit talk judges all the time. I didn't like that, you know, as a lawyer myself and somebody who has, I was not a fan. But I think it's way, way worse to try and intimidate a jury into a guilty verdict. That's screwed up. Like, you know, there's like a bloodlust there that is very strange to me. You know, for a political faction that talks all the time about the need for criminal justice reform and over incarceration, the level of bloodlust they have in trials like this is very bizarre and very much in tension with their overall goals. So he says, if an appeal is needed, I can see Dershowitz coming in and winning on appeal. Just too much material. I wouldn't be surprised if Dersh tries to take the case. Who knows if that's who they'll go with, though. They might go with some. I mean, there's a lot of appellate lawyers out there who would do something like this, I think. let's see. What else we got? Somebody says, watch the whole Timcast last night. Yeah, if you haven't checked it out, maybe I'll put it in a banner. Timcast IRL. Let's see if I can find the link to this. Yeah, is it even here? Oh yeah, it is here. It just is like my lovely fiance, who's my lovely fiance is the one who is like in the banner. Well, that doesn't really help. That's like just a garbage thing. All right, hold on. Let me share the screen and you can see it. Application window. Share. Okay. And now you should see it. Oh well, no, that's whack. Never mind. I give up. Never mind. Oh, never mind. That was all not a thing. Anyway, I'll take a few more questions here. What is the meaning of a reasonable officer? So, I mean, basically, this is defined by, I think, the law, right? Like, you know, and sort of also in reference to expertise. But I'm not actually sure. I don't want to get out ahead of my skis. I don't know that. So he says, do you not have contempt of court laws in the United States? Yeah, sure. We do have contempt of court laws. And it's possible prosecutors might be fined in contempt of court. How do I think Nelson did overall? I'd give him a solid like B+, A-. I thought it was a very solid presentation and a very excellent cross-examinations for the most part. I think you can't give him an A because he called very broad, right? Like that was a disastrous expert, but his other performances was really good. Yeah, Graham v. Condor. That's right. That sets the legal standard for objective reasonableness. Did I smoke a joint? No, I don't do drugs. Sorry. Like people sometimes disagree with you, even though they aren't doing drugs. Just saying. Acquittal, are you for real? How and why? Pretty simple. I don't think the prosecution proved that Chauvin caused Floyd's death beyond a reasonable doubt. Like there's a lot there. You know, Fowler did a good job of explaining the evidence that positional asphyxia generally only occurs to people who are obese. I mean, simple to think about, right? Like the whole idea of positional asphyxia is getting pressed into the ground means you can't breathe. But like generally, they don't find that in lean people because there's not pressure. That's not enough pressure on the lungs. It's in obese people that you really see positional asphyxia as a potential problem. And George Floyd was not obese. George Floyd was pretty lean. So the basic theory that the prosecutors are going for doesn't really make much sense. And there's all this alternate causation or like alternate problem of things like 90% blocked coronary artery, methamphetamine use, fentanyl use, adrenaline, and just got done resisting arrest, hypertension, super high blood pressure. I mean, that could have easily been those events created a heart attack. Like one of the more dishonest moments I thought was, the prosecutor being like, well, he didn't die of a heart attack the rest of the day. It's like, yeah, well, he didn't resist arrest, have this drug cocktail in his system and was just had this massive freak out that would have spiked his blood pressure either. Like that's not on him. So somebody says, I wonder how effective a jury sequester is in a modern day trial. I mean, I guess I would think it could be effective. I would assume part of a jury sequester would be taking away people's phones. Like sequestering a jury is actually fairly oppressive for the jurors. You're kept away from your family. I assume you're not allowed to contact the outside world. And the idea being that since there's so much talk about the case in the outside world, it's sort of interesting when you think about how the United Kingdom handles this. Like they handle it completely inversely. Instead of saying that, the jury needs to be sequestered, they simply ban public comment about the trial while it's happening, generally, to avoid the jurors being biased, which is itself a very oppressive restriction on everybody's free speech. I found the government's appeals to emotion off-putting as well. I thought it was not impressive. Somebody says, yeah, they couldn't prove causation convincingly. Right. That's why I agree. The prosecution could not prove causation convincingly. And again, the burden on the prosecution to prove that. Defense doesn't have to prove it. In today's media and social media environment, shouldn't the USA do away with juries? I mean, that's a Seventh Amendment jury trial, right? I don't know. I could see something along the lines of like, I don't think we should do away with juries. I think they're a good part of our system. Somebody says, how is his O2 saturation 98% if the argument is he died of asphyxia? Doesn't that undermine? Well, the answer is that they made an effort to reoxygenate his blood while they were trying to revive him. That's why that
that's why Nelson actually highlighted, he said, like, I could be intellectually dishonest with you and say something like he had a 98% blood oxygenation level when he was tested. Therefore, he could not have died of asphyxia, because Tobin conceded that. But Nelson's like, I won't do that because that would be intellectually dishonest. I thought it was interesting. Yeah. Yeah, the remarks here demonstrate enough variation of opinion that it's certain if the verdict was entirely based on preponderance of the evidence, there would be reasonable doubt. Unfortunately, the verdict will be based on fear of the gathering lynch mob. Maybe, maybe not. I don't think so. I don't think there's going to be a lynch mob for these jurors. I think somebody's going to do their job. Do I really think the jury was able to stay away from media? And what were the drama TV shows Nelson mentioned that spoke of Chauvin? I don't know how you could enforce staying away from media. And I don't believe that jurors, like, it's like a compulsion to use your phone. I mean, how often do we check our phones every day and suddenly being like, don't use your phone? I just don't think that's a very effective curative. Anyway, so do I think on balance Derek Chauvin had a fair trial? I'm not sure about that. I think it probably needed to be moved out of Minneapolis, and I think the jury should have been sequestered. And I think those things probably made it. Those things probably mean it's not going to be fair. I think this needed to be a sequestered jury. This is massive public focus on this case. It needed to be a sequestered jury. So, okay, that's all I'm going to do for now. I'm sorry I couldn't get to all the comments. I mean, there are a lot of interesting questions and good comments here, guys. So if I didn't get to yours, I'm sorry, but I have to give a fluid presentation while going through them. So I appreciate everybody. Thank you so much for watching. If you are new here, again, Facebook you can like on facebook.com/humanevents media, subscribe and hit the notification bell on youtube.com/humanevents. And on Twitter, you can follow me and make sure if you're on mobile, you can follow me and actually follow and get notifications for my live video. You don't want to get notifications for every treaty, that's done, but you can do that on there. So hope you enjoyed it, and I will talk to you when the jury comes back. Probably also I might talk to you about tomorrow about something completely different. Who knows? Anyway, later.